Yes, sir. That works great. Thank you.
Okay, good.
Morning, Judge. My name is Mike.
Morning, sir.
We've met. Welcome.
Yes, sir.
Thank you for coming this morning. The way we're going to proceed is the commissioners are going to introduce themselves. You'll then have a period of time to make an opening statement. We'll have 20 or so minutes of question and answer, and then I'll watch the clock and I'll reserve 3 or 4 minutes for you to make some closing remarks. So again, good morning. My name is Mike Sasso. I'm the chairman. I'd like Vice Chair Amanda Carl to introduce herself.
Morning, Your Honor. Thanks for being here with us again. It's good to see you again. Amanda Carl, in-house counsel, A. Judah & Sons here in Oviedo, Florida.
Commissioner Andy Bartos.
Judge, good morning. Andy Bartos with the Gray Robinson Law Firm. I'm in Indianapolis.
Commissioner Lauren Blocker.
Good morning, Lauren Blocker. I'm in-house counsel at FIS, and I'm in Ponte Vedra, St. Johns County.
Commissioner David Diamas.
Hi, I'm David Diamas. I'm from Orlando at Kramer Price and Diamas.
Commissioner Craig Dyer.
Hi there, Judge Craig Dyer, formerly of the Public Defender's Office in the 7th Circuit, now retired.
Commissioner Carrie Eisenhower.
Good morning, Your Honor. Carrie Eisenhower, and I'm in Sanford.
Commissioner Scott Thomas.
Good morning, Your Honor. Scott Thomas with the Burr Foreman Law Firm. I am in Ponte Vedra Beach, St. Johns County. Good to see you.
Good to see you.
Okay.
And Your Honor, last but certainly not least, Vincent Citro of the law offices of Horowitz and Citro in Orlando. Nice to see you again.
Yes, sir.
Forgive me for skipping over you, Vince.
Should be least.
You're our host. You may proceed, Judge.
Thank you. Good morning, and thank you for giving me the opportunity to interview here today. My name is Joe Boatwright. I'm a Putnam County Court Judge. I live in Putnam County with my wife, Tammy, my 2 daughters, Lauren and Kate, and my son, Joshua. I'm applying for this position because I want to be an appellate judge, and I think that my diverse background makes me well qualified for this position. A little bit about myself academically. I have my bachelor's degree from the University of Florida, my JD degree from Catholic University, Columbus School of Law, where I graduated second in my class, summa cum laude. Also was on the Catholic University Law Review. I have an LLM in taxation from the University of Florida's Levin College of Law, and an LLM in judicial studies from Duke Law School, where I served on the Judicature editorial board and was editor-in-chief of one of the editions of the Judicature Journal. Professionally, prior to becoming a judge, I practiced law in the public and private sector for 10 years. I worked as a line attorney for John Tanner with the state attorney's office, prosecuting thousands of misdemeanor and felony cases. I then managed the state attorney's office here in Putnam County for 4 years for RJ Larissa. I also had the privilege of being out in private practice for a number of years, representing the citizens in the area in numerous different areas of the law, and also representing a number of our governmental entities, such as the Sheriff of Putnam County, the Supervisor of Elections Office, and 2 of our local cities. As a judge, I've been a county court judge for almost 8 years now, and have handled all types of cases on the county court docket. I'm also an acting circuit court judge and handle numerous circuit court matters throughout the county. I'm currently assigned to part of the family law docket, where I handle the truancy docket. And for the past year, I've been handling probate and guardianship cases in St. Johns County. I'm also the administrative judge here in the county. And in addition, I've had the privilege of sitting once on the 4th District Court of Appeals and also twice on the 5th District Court of Appeal. Not only have I practiced law, but I've taught law for over 15 years at the law school level and the state or at college level. I currently am an adjunct professor at St. John's River State College and also at Liberty University, where I teach in the Helm School of Government. So again, thank you for having me this morning. And if you have any questions, I would be glad to answer those at this time.
Thank you. Your Honor, Commissioner Andy Bartos had your vetting assignment, and he'll begin the question.
Your Honor, good morning. I had your vetting assignment. I also vetted your application when you last applied quite recently. And so I think most everyone on the commission is familiar with your application and with your experience. Could you talk a little bit about what you've done since you last applied? I noticed, for example, on your application that you are now an adjunct professor at Liberty University. So can you talk a little bit about what you've done since your last application to add to the experience that qualifies you to be on the 5th DCA?
Sure. Since last year, like you said, I'm now an adjunct at Liberty University. I teach in the Helm School of Government. I'm teaching a class right now on legal reasoning and logic. I also, since the last application, I have been serving over in St. Johns County on the probate and guardianship docket for about the past year, handling all the probate and guardianship cases. And recently, within the last month, have sat on the 5th DCA. So I think those are kind of 3 things that I've done. And also as an administrative judge dealing with the COVID issues over in our county. And so, yes, sir.
So you've had a full plate. You mentioned legal reasoning and logic as something that you're teaching. Can you tell us a little bit more about that?
Sure. Well, that's a basic pre-law course. I taught the same type of course at Florida Coastal School of Law through the legal research and writing courses. Liberty is a little bit different, where you are actually teaching from a biblical perspective in a lot of the classes, but it's still the same of an entry-level course of teaching how to formulate legal arguments and how to make those arguments at a basic level.
Excellent. I'd like to invite you, and this is going to be a very open-ended question that you can answer in ways, to just share with us your judicial philosophy and your philosophy of the role of the courts. And then also beyond the philosophy, give us maybe a couple of concrete examples of how you have applied that philosophy in practice.
Okay. Well, my judicial philosophy is that a judge should be fair and impartial and follow the law. I think judges should be respectful of the litigants, make timely decisions, and be humble. I think judges need to exercise judicial restraint. They need to know their proper role in the government as one of the 3 branches of government. The judge's job is to interpret and apply the law, not make the law or rewrite the law as they see fit. So, and you had asked a follow-up about applying that in practice.
Yes, if you could give us an example or 2 about how in your work you have applied that philosophy.
I try to do that every day on all those areas. I think I've included some cases in my application about places where I've had to follow the law, even to come out with results that I would not think are right or fair, but in following the law. And so, I think that's something that I do on a daily basis, is try to impress upon those philosophical points. I recently when I sat on the 4th DCA, I think I applied, or I gave you an opinion of, or supplied the opinion where, went through a statutory analysis there. So I think those are some cases.
Thank you. I'll ask you one more question and then turn it over to the others. There's currently a case pending before the Florida Supreme Court in which the court is considering whether to adopt the federal summary judgment standard. Do you have any personal opinions on the merits or demerits of Florida's summary judgment standard compared to the federal standard?
You're speaking of the case, I think they're trying to, or they introduced a dash cam video. Yes. Is that the case you're talking about? Well, I know the Florida standard is very stringent versus the federal standard. I think what the parties are trying to at least persuade the Florida Supreme Court is to accept the Celotex standard that's used at the federal level, which is a little bit more, which gives a little more freedom, I think, in granting of the summary judgment. But I'm going to follow the law as it is now. And then if the Florida Supreme Court decides that they're going to change that, then I would be bound to follow that at the level of the 5th.
Thank you, Judge.
Commissioner Amanda Carl.
Good morning, Judge. Great to have you with us again this morning. I just have one question. Is there a recent case coming out of any appellate courts that you have seen that you believe was particularly well-reasoned, and why?
Out of our courts here in Florida or anywhere?
Here in Florida is good.
Okay. The Lawrence case from the Florida Supreme Court that just came out, that was written by Candidate, I think gives a good opinion on when to depart from precedent. I think that was a case where the court had not been following the mandate of the conformity clause in our Constitution in regards to the Eighth Amendment. And I think Justice Kennedy wrote a good opinion as to when you depart from precedent.
Thank you.
Commissioner Lauren Blocker.
Good morning. I was just wondering what made you decide to get that second LLM in judicial studies and what you learned from it.
Sure. Well, it was, they offered a free scholarship, so that's one. That was always good. But it was an incredible opportunity. I got to sit with 25 different judges from not only around the country, but around the world. Judges on the federal bench and on the appellate courts, and then judges from places like Sierra Leone, Holland, Japan. So it was a great group of judges to learn from. And it's hard to turn down an opportunity when your professors are such as Justice Alito and Brian Gardner, and some of the Alex Kaczynski in writing, some of the others. And so it was just a great opportunity and very hard not to turn down, and was very fortunate to be accepted into the program.
Commissioner Vincent Citro.
Your Honor, it's nice to see you again. I've interviewed you a couple times, so it was hard to kind of come up with a question for you that you haven't already answered. But if you would, walk me through your thoughts on the Dormant Commerce Clause.
Well, the Commerce Clause is, the Commerce Clause says this is the federal government regulating commerce. The Dormant Commerce Clause is where a state would be prevented from regulating commerce. I can't really think of any case that's brought that up recently, except maybe the South Dakota versus Wayfair case, which was the sales tax case that the Supreme Court receded from a longstanding precedent of a physical presence test to allowing the states more into a minimum contacts case, which will now affect state and local taxation at a local level. And so that's the most recent case that I can recall dealing with the Dormant Commerce Clause.
And so if that comes before you, walk us through sort of your thoughts on where the state of the law is relating to the Dormant Commerce Clause and where maybe it should go.
Well, I think you just follow the constitutional provisions in the case law in regards to it. I'll be honest, I don't know what necessarily the state of it is of today, or maybe if you can ask a specific question in regards to it.
Yeah, I think you got to where I was trying to see what your thoughts were on it. So thank you.
Okay.
Commissioner David Diamas.
Hello, Judge. I probably asked you this the last time you appeared before us, but I'll ask you again. Give me your thoughts on PCAs and whether you think they're used too often, not often enough, or about right.
Okay. I think, as I said before, I think there are a number of articles out that discuss the statistics on the number of PCA opinions throughout the state. I don't recall, but I want to say, on the 4th, they might have been in the high 70s. On the 5th, they might have been in the 80 percentile in that range. Coming from the trial court, that seems very high of not writing opinions because we're required to give factual findings and conclusions of law pretty much on a what I would consider just about everything that we do. So we tend to write quite a bit. I would say that I do understand that when you write an opinion at the appellate level, you're usually writing an opinion when you're reversing the lower court and then giving them direction. Maybe there is a particularly unclear area of the law that you're trying to clarify, or it's an overly complicated case and you just want to give the parties some direction as to why you ruled the way that you do. I also understand there's reasons you wouldn't write if you have a case that's just so clear, like a plea colloquy that you went through. It's a perfect plea colloquy given by the judge. And so there's no reason to write an opinion on that issue. There's also the situation, I know that Judge Edwards came and spoke over at our Inn of Courts and discussed it. is that, the more that you write in an area, lawyers love to take every case that they can and try to use the precedent to argue your case. And so you have to be very careful that you don't continue to add if the law is already settled. Obviously, if the trial judge has written such a fantastic order, there might be also a reason not to write in that situation. And I do understand that clients and lawyers, after spending all the time and effort and money into an appeal, don't want to get back something that just says PCA on it. I understand that, and I understand that it also prevents the parties from being able to appeal a case. I can say, and it's just been a limited sample size, but the 3 times I have sat on the appellate courts as an associate judge, we've written multiple opinions, and maybe I just drew the short straw, but I've had to been assigned 2 out of the 3 times I've sat to write an opinion. So I think that's kind of my position. I tend to write a lot now, and I would think that I would continue to do that in the future.
Thank you.
Commissioner Craig Dyer.
How you doing, Judge?
Good morning, sir.
If my memory serves me correctly, the last time you interviewed with us, your name went up to Tallahassee, correct?
Yes, sir.
Okay. If we were to place you in the 6 that go before the governor again this time, how would you handle that Tallahassee interview? Would it be any different than the way you did in the past?
I've interviewed with this panel 3 times and been sent out. Then I've interviewed with the general counsel's office, and every time I have been interviewed with the governor. The interviews with Governor Scott were a lot shorter. The interview with Governor DeSantis was a lot longer. But sometimes there's very qualified people, as you well know, in this group, and so sometimes it seems individuals get it on the first time, but I know there's a number of judges on the 5th District Court of Appeal right now who's taken them multiple times to get appointed. I just go up there and present myself as I am and interview. So I don't think I would change anything in the interview process. I don't know that I said anything or did anything. It's just sometimes there are maybe a better candidate or somebody at that point that the governor likes better.
Okay. One additional question. You are in a situation where you're sitting on the 5th DCA. You've read the briefs. You are recognized that oral argument is coming up, and you also acknowledge the fact that both sides have missed the point entirely of the case and somebody is going to get hurt. What would you do, if anything?
Well, it depends on what you say would get hurt. So typically, I don't think it's a judge's job to start creating arguments for the parties. Obviously, if you're looking at a case, I think there's a tipsy coachman doctrine that if you're looking at a case, you can, if maybe the trial court didn't rule on a certain issue, but you feel like they did make a proper argument, it's not briefed in front of you, but they did make a proper argument, then I think you can affirm on that. I don't think you can overrule on that. I think probably the more important issue that you're discussing comes up when you have a criminal case and you're looking at fundamental error. And even though the parties haven't briefed that, I think it's the court's obligation to, at that point, if there is fundamental error, to try to resolve that. But I would say generally, I don't think it's a judge's job. I don't try to do it at the trial court level. I don't think it's appropriate at the appellate court level to start becoming an independent judge where you begin to start creating arguments and trying to get through and try to make a decision. I think there was a case recently. I know there's been some sentencing cases recently, but I think about a case, Jesse Bourbon case that came up out of our circuit that I think the judges did that on, went kind of a little bit and started to make up arguments that weren't briefed before the court. And so I tend to agree with the dissent in that case.
Thank you very much. I have no further questions.
Thank you, Commissioner. Commissioner Carrie Eisenhower.
Good morning, Your Honor.
Good morning, ma'am.
You may have answered this in the past, but since I'm new to the commission, I wanted to understand your process when interpreting a statute, what you use in statutes.
Yes, ma'am. I think a candidate opinion that came out in 17 State versus Dubon is a very good case. And it takes you through the process of interpreting a statute. I think they were just very simply, if you look at the plain language of the statute, give it its reasonable meaning. If it's clear, you don't go any further. If there's an ambiguity, if it's susceptible to two different meanings, then that case tells you that at that point, it's appropriate to look at different parts of the statute, maybe look for a definition section in the statute and the introductory part that might define the term, dictionary definitions that would be defining the term as it was in the statute at the time that it was enacted would be appropriate. There may even be case law that has interpreted that ambiguity. And then finally, you could go to rules of statutory interpretation, but that's how I would handle that.
Thank you. I also wanted to ask if you could describe a time in your career when you had to take a position that supported a position that your colleagues were opposed to.
Sure. I think recently as an administrative judge and not COVID related, we had some maintenance and health issues in the courthouse. And I was trying to, we're back in the courthouse here. And I requested of the chief judge that we stay in the courthouse because we'd already been shut down long enough. Some of my colleagues disagreed with me and the chief judge agreed with my colleagues instead of me, but that's okay.
All right. Thank you very much.
Yes, ma'am.
Thank you, Commissioner. Commissioner Scott Thomas.
Your Honor, if I could follow up on something you said in your introduction. You said you want to be an appellate judge. We have a bit of an overlap here. I think the Seventh Circuit JNC was convened to fill an opening on the circuit court created in Putnam County, where you are, by the retirement of your colleague, Judge Christensen. Did you apply for that circuit court vacancy? No,
I did not. No, sir.
So given the obvious sincerity of your desire to be an appellate court judge, I think the question is why? Why do you want to be on the appellate bench?
I have sat 3 times as an associate judge, but the first time I applied, I had sat originally on the 5th, and I just enjoyed the process. I really liked it. I've been a trial court judge for 8 years, and this would be a different type of practice, but something that is writing intensive. It's requires critical thinking. I think things that mate or match my skill set very well. And so I enjoyed the opportunities the 3 times that I've had to sit. So that's why I want to do this full time.
My understanding is that when you sit like that by designation on the DCA, it's at an invitation of a sitting judge. Is that correct?
I think so. I think so.
Do you know who makes the invite for you, or is that you just get it?
I do not know. I don't. Okay. I don't recall. So Spencer Levine on the 4th DCA, he and I went to Duke together, but I think I sat for Judge Gerber. The last time Judge Evander called, I think I was sitting for Judge Grosshand's empty seat. And I'm not sure the prior time, I think I sat for Judge Cohen the first time that I sat.
Thank you, Your Honor. I appreciate it. It's good to see you again.
Yes, sir.
Judge, I have a hypothetical for you.
Okay.
Assume you can only keep one: the separation of powers in the Constitution or the Bill of Rights. Which would you choose and why?
We could only keep one separation of powers?
No, you can either keep the separation of powers in the Constitution or the Bill of Rights.
I would say, might not be the right answer, but I would say
there's not a right answer.
Okay. I would say the separation of powers. I think it's very important, the separation of powers, if they're followed, and the way that the different branches work together, and especially with the judiciary being a limited form of the government. So I would much prefer rather to see that separation of powers than some of the rights that are delineated in the Bill of Rights.
Okay. Thank you. Well, that concludes the Q&A portion of our interview. I'd like to give you an opportunity to make some closing remarks.
Okay. Well, again, thank you for having me here today and giving me the opportunity to interview. I know not everybody brings everything into this process, but I would ask that you would consider my judicial philosophy that I've outlined here today and my broad experience that I've outlined, as well as my academics and my writing abilities and my work experience in considering me for this position. And I would hope that you would consider forwarding my name to Governor DeSantis. So again, thank you for having me here today. And Mr. Sasso, is it okay if I go ahead and log out, sir?
Thank you for your service, and yes, sir, you may log out.
Okay, thank you.
Thank you.